form, aren't I? Okay. This one. Okay. All right. Welcome back, everybody. Yes, the technical whizzes have fixed us up, so we're ready to go. Still muffled? No. Okay. Says okay. So I'm presuming the sound's all right. So we shall carry on. But if you're having problems, just let me know. And the whiz kids are just around the order. Okay, La. Good to hear. While I'm looking at the chat box, quick question about references for tort law books. Would you provide reference book lists? Well, there's only one book that you need to get if you want to. I mean, the course manual is very good. The tort law book, the tort course manual, I think is better than the contract one. The tort one is really spot on. And if you want to have another reference, there's a very good book by Rick Klofczewski called Tort Law in Hong Kong. I'll type that in for you. Okay, so there you are. I'll put that in there. Okay, so there's the reference book, Tort Law in Hong Kong by Rick Klofczewski. I'm not sure what edition it's up to now, but it's a very good book. It's easy to read, and it's more than you need to know for our course, that's for sure. But if you want to have extra reading, that's a good book. But the course manual itself has got all the must-know parts for our course. All right, so so let's carry on. I presume, if again, if you have problems, technical problems, let me know. Okay, so the elements of negligence, and of course, we'll come to causation tonight. So perhaps I should flip the last these two bullet points perhaps should be around. So you got A, B, C, D. But of course, there's got to be damage. Okay, also worthy of note, and I think I put this in another PowerPoint, the burden of proving all of these elements is on the plaintiff. Okay, so important point to make. When we come to defenses later, the burden of proving a defense will be on the defendant. And the burden of proof is important. And if you're doing an exam question or advising anybody, which is often what you're doing in an exam question, then be aware of who has the burden of proof. Okay, good. So that's... So breach of the duty, standard of care, obviously the defendants will be in breach if their conduct falls below that which was reasonable to expect of them in the circumstance. So really up to the judge in a particular case as to whether there will be breach of the duty or not. And of course, who is the reasonable person? Who is the reasonable defendant in the circumstances? Well, obviously it is a changing or varying standard depending on the circumstances. And of course, the judge will be the one who determines it. Glasgow and Muir must-know case. In Glasgow and Muir, remember, the tea was spilt on some children, and the owner of the property was sued for negligence. Was a duty of care owed? Yes, it was. But was there breach? That was the question. And the court said, well, you couldn't expect the defendant in the circumstances to take all necessary steps to make sure nobody was ever injured at any time. You'd have to clear the whole building of everybody every time the tea urn went into the room. And so the court said that is simply too much. Okay, so the courts are not going to impose unreasonable standards, if you like, or another word is onerous standards. Okay, so they will be reasonable. Okay, very much overworked word, isn't it? Reasonable. And with regard to minors, remember it depends on the age of the defendant. Yes, I've amended the PowerPoint. So in McHale and Watson, on page 50 and the other cases, the court looked at the standard of an ordinary child of that age. And of course, McHale and Watson, the defendant was 12, Chen and Wong, 14, and in Orchard and Lee, 13. Okay, so the standard will vary depending on who the defendant is, and it will be a reasonable defendant in those circumstances. So looking at minors is quite instructive. Okay, and then getting on to standard of care. That's a good one. Standard of scare. Okay, if the defendant is a person in a particular skilled job or profession, then the test will be the standard of the ordinary skilled man exercising and professing to have that special skill, which sort of begs the question, who is the ordinary skilled man? So it's really will be up to the court to decide. They will rely on expert evidence. There will be expert witnesses, and so the court will have to rely on the expert evidence to decide whether there's breach. Okay, so it's okay. There'll be no breach if the defendant exercises the ordinary skill of the ordinary competent man exercising that particular art. Well, what do you mean by ordinary again? Okay, so again, it's going to be the judge in the case who will decide. And in the case of doctors in particular, means failure to act in accordance with the standards of a reasonably competent medical man at the time. Okay, so there may be more than one standard, depends on the circumstances. Okay, and then with regard to going back, Wong and JSM. In Wong and JSM, remember the solicitor newly qualified. She's only qualified for about 2 years, and she was involved in a conveyancing transaction, and the method of completion of land contracts in Hong Kong is not simultaneous exchange of money and documents. It's what we call completion by undertaking. What do you mean by undertaking? It means a promise. It's a promise by the vendor solicitors to pass over the title deeds, but sometime after having already received the balance of the purchase price. And so there is a danger there, of course, that the vendor solicitors have got the money before the title deeds are passed to the purchaser. And this is what happened in JSM, Wong and JSM. The vendor solicitor did abscond with the money, and the extraordinary, or if you like, the extra risk involved in Wong and JSM was the fact that the vendor solicitor's firm was a one-man law firm, which meant what? It meant that you only needed one signature to withdraw the money. Okay, so what the solicitor should have done is recognize this extra risk, and they should have advised their client to insist on what we call formal completion, that is, simultaneous exchange of money and documents. Okay, interesting though, because in Wong and JSM, the Hong Kong Court of Appeal said there was no breach. They said, well, the young lady was just following the ordinary standards. The normal practice in Hong Kong is completion by undertaking. But the Privy Council said, no, no, no. The young lady should have pointed out the special risk associated with the vendor solicitor's firm being a one-man law firm. Okay? All right, so that's Wong and JSM. A good one if you ever get to be practicing as a lawyer, and I hope some of you get that far. Okay, so that's the Bolam test, got that one. Now, with regard to standard of care generally, the standard of a reasonable employer depends on the circumstances at the time, but Wong Kit Chun and Wishing Long Hong, must know case, must know. Okay. Can I share more skills? Okay, well, question from Chan Shung about exam skills. Well, my advice is, everybody, learn your must-know definitions, learn your must-know principles, remember your must-know cases, okay? And we shall be covering examination skills when we deal with the revision course, okay? Because remember, when you answer examination questions, you have to identify issues. And what is an issue? A question for the court to decide. And how do you identify issues? By using definitions and principles. So that's the way to prepare for exams, okay? All right, and you then apply your tools to the facts, to the particular question, okay? And don't be frightened if you can't come to a black and white conclusion, okay? So there you are. All right, and then, so with regard to standard of care generally, with regard to an employer, it depends on the reasonable employer in the circumstances at the time. So in Wishing Long Hong, remember the employee fell down and was killed. Did the employer owe a duty of care? Yes. Was there breach of the duty of care? The court said yes, because a reasonable employer would have provided sufficient lighting. There were insufficient torches in Wishing Long Hong, so the court found there was breach. And of course, causation and damage. So all the elements of negligence were proved in Wishing Long Hong, and so the plaintiff was able to claim damages. But as we will see later on when we get to defences, the defendant was able to successfully prove contributory negligence. Now, contributory negligence is not a total defence, it's just a partial defence. And as we'll see later on in Wishing Long Hong, the damages that the plaintiff could claim were reduced by 10%. I think it's 10%. I'll check on that later. All right. So that's Wishing Long Hong, must-know case, everybody. Cheung and Lam, don't worry about Cheung and Lam. Okay. So also other factors the court might take into account. What is the magnitude of risk or likelihood of occurrence of the particular event? Well, Bolton and Stone, the number of occasions in which a cricket ball was hit out of the ground was very, very rare, 6 times in 30 years. So the court found that the likelihood was so small there was no breach of the duty of care. But it then depends on the facts, okay? So you could find another situation in which the cricket ball is hit out of the ground much more frequently, as indeed at the Hong Kong Cricket Club. Okay. All right. Also, the gravity of the injury and the damage caused. Paris and Stepney, remember the appellant only had one eye, one good eye, and he was blind in the other eye. And what happened was that there was an accident and the other good eye was damaged, so he was rendered totally blind. So obviously that's a much more serious situation than if you have 2 eyes and you lose one. Okay. So that's Paris and Stepney. Also social utility, what is the usefulness of the activity involved? And De Born, of course, and Bath Tramways, the Second World War case involving ambulances donated by the Americans to the British, and there was an accident largely caused by the fact that the ambulances had their steering wheel on the opposite side of the English ones. Okay, so the court said, well, these ambulances of great social utility, there was no breach of the duty of care in De Born. Also, an interesting case on page 56 of your course manual involving rugby players, the case of Sutton, S-U-T-T-O-N, worthwhile looking at Sutton, in which the court said that rugby is a desirable activity. And so the court shouldn't impose unreasonable or onerous conditions on the defendant. And if you read the Sutton case, you found that somebody was injured when they sort of dived over the try line, and that particular part of the field was a bit more dangerous than the other parts of the field. And the court said, well, we can't have varying standards depending on which part of the field you're on. So they said rugby is a desirable activity, no breach of the duty of care. Okay, of course, you've got to encourage physical activity. All right, good. Also, with regard to other factors, the difficulty of overcoming the risk in the Wagon Mound on page 57, discharge of oil into Sydney Harbour could have been easily prevented. Of course, Wishing Long Hong yet again. Okay, inadequate provision of torch is obviously very easy to overcome the risk in that one. And then the common practice, which we've already looked at with regard to solicitors. How does the court decide what the requisite standard of care is for professionals? Well, you've got various codes like the Road Users Code for car drivers. You've got the Code of Banking Practice for bankers. You've got legal practitioner rules for solicitors, and you've got the bar code for barristers. Okay, but of course that's not always conclusive. That standards could vary a little bit depending on the facts. So Wong and JSM, for example, completion by undertaking was the normal practice in Hong Kong, but there was still breach of the duty of care in Wong and JSM. Okay, so that's revision, what we covered last time. Nettleship and Weston, everybody, must know case, must know. Because Nettleship and Weston deals with the situation where the defendant is a car driver. Now, Glasgow and Muir says the standard of care is that of a reasonable person in the circumstances, which means what? That the standard of care varies depending on who the defendant is. But with regard to car drivers, everybody, very important to note that there's only one standard for car drivers, and that is that of the competent and experienced driver. Nettleship and Weston is your standard of care is that of a reasonable person in the circumstances, which means what? That the standard of care varies depending on who the defendant is. But with regard to car drivers, everybody, very important to note that there's only one standard for car drivers, and that is that of the competent and experienced driver. Nettleship and Weston is your case, is mentioned at the bottom of page 32 of your course manual. In my opinion, out of place. It should be up with breach of the duty of care. So watch out for Nettleship and Weston, because you could well get a question in the exam dealing with a traffic accident. So duty of care would not be an issue normally with traffic accidents if the damage suffered is directly caused personal injury or property damage. But the issue that could come up in traffic accident cases is, was there breach of the duty of care? And there's only one standard, that of the competent and experienced driver. So when the learner driver in Nettleship and Weston crashed the car, then the court said, well, bad luck, learner driver, you will be judged and by the standard of a competent and experienced driver. And the competent and experienced driver would not have been involved in such an accident. Okay, and the interesting thing about Nettleship and Weston was that the person who was suing the learner driver was their own driving instructor. Okay, so all right, the driving instructor won the case, but as we'll see later on, the learner driver was able to rely on the defence of contributory negligence, and indeed the court reduced the quantum of damages in Nettleship and Weston by 50%, which is probably fair enough, because you'd think the driving instructor should have been better at his job. Okay, all right. So interesting case. Nettleship and Weston, everybody, must know case. It's your must know case on car drivers, and it's a very good example of contributory negligence. So we're going to mention Nettleship and Weston again when we get to defences to negligence. Okay. Now, everybody, I've thrown this in. Section 62 of the Evidence Ordinance is not in your course manual, but I think you'll all agree with me it's very important, should be in the course manual. And Section 62 of the Evidence Ordinance is headed Convictions as Evidence in Civil Proceedings. And Section 62 sub 1 says, in any civil proceedings, the fact that a person has been convicted of an offence by or before any court in Hong Kong shall, and subject to something else, be admissible in evidence for the purpose of proving, where to do so is relevant, to any issue in those proceedings. Now, of course, let's say the car driver is convicted of careless driving. Well, certainly that's relevant to a civil action for negligence. Okay. So that's section 62 sub 1, but it's important to note section 62 sub 2, which says that the burden of proof is reversed and it is put on the legal burden shifts to the defendant. Okay, so section 62 is a help or an aid to the plaintiff to prove breach of the duty of care. And so remember, if the traffic accident is such that the plaintiff is knocked unconscious, for example, he may not have any evidence to give. And so section 62 of the Evidence Ordinance is very, very useful if there is a relevant criminal conviction that the defendant is liable for. Okay, and not only that, the legal burden shifts to the defendant. Okay, so section 62 sub 2 is the one that says that the legal burden shifts to the defendant. Okay, so must know, everybody, section 62 evidence ordinance, and I think you'll all agree with me, very, very useful evidence. By the way, if sort of expanding on that a little bit, let's say a driver is convicted of careless driving. Does that necessarily mean he's negligent in the civil action? The answer is not necessarily, because if you are charged with careless driving, a criminal offence, it's a fairly minor offence, and the sentence is usually just a small fine of $300 or whatever it is. Okay. Now, if you are a professional driver and you're charged with careless driving, say you're a taxi driver, you may well plead guilty, so everything is over and done with quickly and you can get back to driving your taxi. So you may well plead guilty for convenience sake, because if you plead not guilty, then you have to come back to court on another day, you've got to spend time, and you've got to go through a trial. Okay. So it may well be that the driver in that circumstance may be able to prove that he is not negligent, okay, even though he may be charged with careless driving. Okay. So, but of course, usually it's pretty strong evidence, and it certainly would be very strong evidence if it's the defendant actually did go to trial and lost in the trial. Okay. So that's section 62 evidence ordinance, everybody. Must know, must know. So Chan Sheng, you want to know about examination skills, must know section 62 evidence ordinance. And I challenge you, everybody, go and look it up. It's not difficult. I've actually got it on my smartphone right now. I'm reading from it. Okay, so there you are, section 62 evidence ordinance. Very good, powerful aid for a plaintiff in proving breach of the duty of care. Evidence of any relevant criminal offence, could be careless driving, could be drink driving, whatever, is admissible in evidence, and not only that, it is powerful evidence and the burden shifts to the defendant. Okay, and the other very important aid in proving breach is res ipsa loquitur, which is covered very briefly at 1.4.4 in your course manual. First of all, know what the Latin expression says. The thing speaks for itself. Res is the thing. Ipsa is itself. Loquitur means speaks. Okay. So the thing speaks for itself. It is a rule of evidence relied on by the plaintiff. And the test is the thing, whatever it is. It could be a crane or some form of machinery under the management of the defendant, and the accident is such as in the ordinary course of things does not happen. If the defendant uses proper care, then the thing speaks for itself. Okay, and the case you can cite is Scott and London and St. Catherine Docks. Okay, important to note though that with res ipsa loquitur, the burden of proof remains with the plaintiff, unlike section 62. So the burden of proof does not shift onto the defendant if the plaintiff is relying on res ipsa loquitur. And I've got the following PowerPoint deals with and Lee, contrast, KMB and Chung. In and Lee Privy Council case, the defendant was able to prove that he took reasonable action when cut off. Okay. And I've corrected my typo there to take, yeah, that's good. So, I mean, you could say, well, was the thing, the bus, whatever it was, under the management of the defendant, and the accident such in the ordinary course of things does not happen if the defendant uses proper care? Well, then you're liable, aren't you? No, but the driver was able to prove he did take reasonable action in the circumstances. I think he had to take the action to avoid a head-on collision. By contrast, KMB and Chung, the defendant's response to being cut off, the court found on the facts was not reasonable. Okay, so it does depend on the facts of each case and expert evidence. But res ipsa loquitur, everybody, is a very useful aid to a plaintiff in proving breach of the duty of care. Okay, everybody, so that's I'll run through a breach of the duty of care. must know Glasgow and Muir, must know Nettleship and Western with regard to drivers. I'd also suggest must know the Wishing Long Hong case because it's very easy to follow. The other cases, I think DeBorn and Sutton are quite useful. You could get an exam situation where somebody is, driving a car exceeding the speed limit. There could be an accident, but it may well be he's driving to a hospital to save somebody's life. Well, obviously, there's a high social utility in that situation. Okay, so there you are. If you're playing any sort of sport, anybody, Sutton's an interesting case. All right. So rugby is a desirable activity. Okay, good. So that's it for breach of the duty of care. So that's sort of by way of revision. Now we're going to get on to the next element of negligence, and that is causation. So just one moment while I switch the PowerPoint. Oh, isn't that brilliant? I mean, Space have spent some money finally, and I've got two screens tonight, and the second screen is touch screen. And oh my goodness, very easy to operate my PowerPoints here. Okay, good. So let's have a look at causation. And causation's covered pretty well in your course manual, starting somewhere. I'm looking for a page reference. Yes, starting on page 58. And with regard to causation, it's quite a neat topic in a way. There are two major aspects to causation. One is the so-called but-for test, and we'll look at what the but-for test is. And the must-know case on the but-for test will be a case called Barnett. Barnett's going to be must-know. The facts are very simple, and it's a good illustration of what we mean by the but-for case, but-for test. Okay, and so there must be some physical cause and effect. That's what we mean by the but-for causation. Or another way of saying the same thing, would the damage have occurred even if the defendant was not in breach? Well, if that's the case, then there is no causation. Okay, so the other aspect of causation is there could be more than one event which satisfies the but-for test, in which case the court's got to decide which one of the possible causes is the effective cause. Okay, so this is where we look at a Latin expression called Novus, Actus, Intervenians. What do you mean by Novus, Actus, Intervenians? Novus means new, Actus is act, intervenes. So a new act intervenes and breaks the chain of causation. So in other words, there may be two possible causes of the accident, the damage. Which one is the effective cause? Well, it will be the first event unless the second event is not reasonably foreseeable. And that's the test that we'll be looking at. So if the second event is not reasonably foreseeable, then that will break the chain of causation, and the second event will be the effective cause. Okay, so if you like, the first event, whoever caused that first event will get off. So we'll be looking at some cases there. The must-know case with regard to Novus Actus Interveniens is a case called Knightley and Johns, but there is another case on similar facts, the Lodge case. We'll look at that as well. So basically, everybody, I'd say there are only three must-know cases on causation. Not difficult, okay? So, and also remember, as with the other elements of negligence, the burden of proof is on the plaintiff, on the balance of probability. So that's what we've got here. So causation is primarily a question of fact, okay? Did we have physical cause and effect? But there could be legal principles involved if there's more than one possible cause, okay? And that's where the courts will be trying to establish, well, what is the effective cause, okay? All right, so in other words, the analysis has two aspects. There's got to be physical cause and effect, the but-for causation. And then if there's only one possible cause, well, that's then the effective cause, okay? And how do you know whether the but-for test is satisfied? Well, another way of asking the same question is, would the damage have occurred even if the defendant was not in breach? Barnett is your case. Barnett's on page 59. And the facts are sort of interesting. Be careful when you drink something. I mean, we've already looked at Donahue and Stevenson, all right? So if you're going to drink from a bottle, make sure you know what's inside. Make sure there's not a decomposing snail, which might cause gastroenteritis. Also cause nervous shock, by the way, in Donahue and Stevenson. In Barnett, what happened is that the plaintiff and two co-workers got sick. They had a drink of tea. But I'm going to have hot chocolate at the break. I'm not going to have tea. I don't need caffeine to get excited about tort law and contract law. Do I? No, I'm going to have my hot chocolate. But in Barnett, they drank tea and got sick. Why did they get sick? Because the tea was laced with arsenic. Okay. So when they got sick, they went to the casualty ward of the hospital for treatment. They went to the A&E, accident and emergency, which was what I did back on the 30th November last year, okay, when I had that stomach pain. It was terrible. They still haven't found out exactly what that was. At least it's not cancer. So there you are, I went along to the hospital. So the doctor at the casualty ward refused to see them, advising them to go and see their own doctors. Now, did that doctor owe a duty of care to Mr. Barnett? Yes, they did. Was that doctor in breach of the duty of care? Yes, he was, because the doctor should have seen him straight away. This is an emergency, okay? Don't say go away and see your own doctor, okay? So the man died, Mr. Barnett died, so his widow sued the hospital for negligence. So this is a good case for us to examine the elements of negligence. So in Barnett, did the doctor at the hospital owe a duty of care to the plaintiff? Yes, clearly so. Even before Donahue and Stevenson, the duty of care is owed by a doctor to a patient. Was the doctor in breach of the duty of care? Yes, because he had not come up to the requisite standard. I mean, doctors should have recognized this is an emergency and take emergency action. Okay, all right. But was there causation? Good question. The court said there was no causation. Why not? Because Mr. Barnett would have died anyway. Okay, so there was no causation. The but-for test was not satisfied. Okay, so there you are. Barnett's a good case. The facts are fairly simple. And so the court found that there was no causation, therefore no negligence. Okay, obviously there was damage, by the way, yes. So the only element missing from Barnett was the element of causation. Okay, I've got another case on the screen, which again, don't worry too much about, although it did involve a worker on the building site, and he's supposed to have worn a safety belt, but as it turned out, he wouldn't have worn it even if it had been provided. So there was no causation in the Williams case. Don't worry about that. Barnett is your must-know case. Okay, Barnett, you don't need to remember the rest of it. Chelsea and Kensington Hospital Management Committee. Okay, so Barnett is your case. Just simply say it as the Barnett case. That's good enough. Okay, so Barnett, your must-know case on the but-for test. And then moving on to the second aspect of causation, even if the but-for test is satisfied, the defendant's negligence must be shown to be the effective cause. Now, this is where there's more than one possible cause. Okay, so this is what we mean by the effective cause. So effective cause is normally a matter of common sense, follows the but-for test. However, not always so when there's more than one competing possible cause. Okay, sort of like a chain reaction type of thing, where you have one event and then there's another event, almost like a Charlie Chaplin movie, or Buster Keaton. Those old silent comedians. Okay, so they'd walk along and they'd fall over, and that would cause some sort of chain reaction. All right. So what about effective cause when there's more than one competing possible cause? How does the court resolve this? Well, the court will look to see whether the second event is a Novus, Actus, Intervenians. All right, Latin, I know. So Novus, Actus, Intervenians. Novus is new, Actus means act, Intervenians means intervenes. Okay, so what happens here, there's more than one possible cause. How does the court decide what is the effective cause? Well, they will look at the degree of foreseeability of the second event and also the manner of its occurrence. Now, if the second event was not reasonably foreseeable, that will break the chain of causation. So the second event, the second cause, will become the effective cause. Okay. However, if the second cause or the second event was reasonably foreseeable, then that will not break the chain of causation. The first cause will remain the effective cause. So that's how it works. And in sort of layman's terms, did the second independent event break the chain of causation? Okay. So the leading case on this is Knightley and Johns, which we're working up to. But there's another case called Wright and Lodge. Knightley and Johns on page 65, Wright and Lodge on page 66. They're sort of reasonably similar. Okay. A little bit more on what do you mean by reasonable foreseeability. Well, obviously, natural events would be reasonably foreseeable, so they would not break the chain of causation. Okay, rain and wind, but sometimes they might have exceptional acts of God, you call them, that could break the chain of causation sometimes. All right, again, it does depend on the facts. And of course, that expression reasonable foreseeability is always a bit vague. Okay, also, what else is reasonable foreseeability? Instinctive human responses to save another one. Okay, that would be reasonably foreseeable. Also, reasonable human responses, as in the Chun Yat Nam case, an elite police constable was injured by a plastic bullet. He then resigned, but he could still claim damages for unemployment because it's reasonably foreseeable that the first event would have caused his sort of mental problems. Okay, pygmies and pointers is an interesting case. In pygmies and pointers, somebody was injured in an accident, then committed suicide, and the court found that that was reasonably foreseeable that such a person who suffered head injuries might indeed commit suicide because he suffered from a mental illness. So that was not. There was no break in the chain of causation. That was not a Novus Actus Intervenians. So that's pygmies and pointers. I haven't got a page reference for that. Okay. Again, they're interesting cases, but the must-know case coming up is Knightley and Johns, and a case on very similar facts is Wright and Lodge. So Knightley and Johns is the case I suggest is must-know, because Knightley and Johns gives you virtually everything you need to know about Novus Actus Intervenians. And I'm just checking to see where that is. Yeah. So Knightley and Johns, page 65. Wright and Lodge is on page 66. So let's go through Knightley and Johns. I'm going to go through a little bit of detail because this is the leading case on Novus Actus Intervenians. And the facts are interesting in that a car was driving through a one-way tunnel. And I emphasize a one-way tunnel. And of course, not that I'm driving much these days, but in Hong Kong we have a lot of tunnels. And every time I was driving through a tunnel, I said, I hope I make it to the other end. Anyway, so what happens here, though, is that the defendant's negligence caused an accident at the tunnel exit. So he was this, okay, so that was the first incident. And then the police arrive, obviously, to investigate and manage the traffic. So that is reasonably foreseeable that the police would arrive to investigate and control the traffic. I actually saw a little incident in Causeway Bay yesterday where I think a minibus had run up the back of a van and the police were there, sort of a little bit, but they weren't in a tunnel. Okay. So what happened here was that the police arrived to sort out the situation. Now, the police have what we call standing instructions to handle these sorts of things. And a superior officer should have known about these standing orders, and what he did was that he undertook a series of actions which were not in compliance with these standing orders. First of all, he should have stopped the traffic going through the tunnel. He, instead of doing that, he sent an officer on his motorbike against the flow of traffic to, try to stop the traffic flow. And what happened is that the police officer on his motorbike collided with the vehicle, another vehicle, and was injured. So the person who was suing here was the police constable on his motorbike. He was suing his superior officer because the superior officer was acting in such a way which was not in compliance with normal standing orders that the police have in these circumstances. Okay, so the issue was the original driver whose car broke down in the tunnel, was he liable for the injury to the police constable on the motorbike? That's the issue. Well, certainly the but-for test was satisfied with regard to the first driver, but for the fact that his car broke down, actually broke down causing an accident at the tunnel exit. But then there was another possible cause, and that was the actions of the police. Now, was it reasonably foreseeable that the police would arrive to investigate and manage the traffic? Yes. But what was not reasonably foreseeable in Knightley and Johns was that the police would act in such a way, a series of acts of ineptitude by the police, contrary to their normal standing orders. And the court said that this was not reasonably foreseeable. It was not reasonably foreseeable that the police would be so bad, if you like, in handling the situation. Okay, why were they bad in handling the situation? Well, they should have closed the tunnel to traffic first. They shouldn't have sent the police constable on his bike against the traffic flow. And indeed, on the facts, they could have used a radio or telephone to close the tunnel. So they didn't have to send the police constable on his motorbike to go and shut the tunnel. They could have simply used a telephone, okay? And they should have closed the tunnel anyway. So the police constable successfully sued his own police superior officer because the actions of the superior officer were not reasonably foreseeable. And that broke the chain of causation. Therefore, the effective cause was the, if you like, the actions of the superior police officer. The effective cause was not the negligence of the original driver whose car broke down in the tunnel. So that's Knightley and Johns. Remember what a Novus Actus Intervenians is? It's a second cause which breaks the chain of causation because it's not reasonably foreseeable. And of course, those words reasonably foreseeable are not, black and white in their meaning, are they? So there you are. That's Knightley and Johns. Now, Wright and Lodge is also an interesting case. Facts are reasonably similar. Wright and Lodge on page 66. Okay, I mean, Wright and Lodge is a good case, fine. But you only need to know Knightley and Johns. But let's go through Wright and Lodge because it's on page 66. Actually, I think your course manual's got the year wrong. I think it actually should be 1983, but nothing much turns on that. So you notice that the facts are reasonably similar to Knightley and Johns. A car broke down on an unlit highway, so you're in the dark. The driver was negligent when she tried to restart the car without first moving the car from the roadway. Okay, well, if you're in that sort of situation, though, it's a bit of a stressful situation, an emergency. A lot of people find it hard to think straight when you're in such a stressful position. So anyway, she was negligent. She tried to restart her car without first moving it from the roadway. You could argue, well, hang on, she's only a lady. Probably couldn't push it. Well, yeah, you release the handbrake and put it in neutral and push it. Cars are not that difficult to push. Anyway, a lorry collided with the stalled car and then several other vehicles collided with the lorry. So you've got a chain reaction. People were injured and people were killed. So it was found by the court that the driver of the lorry drove the vehicle recklessly the court held that the negligence of the lorry driver constituted an intervening act, Novus, Actus, Intervenians, because the lorry driver was driving in such a way that was not reasonably foreseeable. Okay, why? Because the lorry driver should have acknowledged the fact that, you know, this is a tricky situation. You've got a highway which is not well lit. You've got a car in front of you, okay, and you should have been driving more carefully. And it was not reasonably foreseeable that the lorry driver would be so negligent in driving his lorry, which reminds me of a case involving my poor late cousin, my cousin Anne. She was killed in a traffic accident in Australia. It wasn't a car stopping or anything. Well, she had to stop because there's a whole build-up of traffic ahead of her. So her car was stationary on a highway behind, you know, a whole line of traffic, and a lorry driver came up behind her and plowed into the back of her. Her car caught fire and she was killed. Okay, so a very nasty accident. The lorry driver found out that the lorry had bald tires, was unregistered, and the driver was unlicensed. Okay. All right, so there you are. Whenever I look at Wright and Lodge, I remember my poor departed cousin Anne. Okay, so there you are. So lorry drivers in particular should be careful because, you know, it takes a longer time to stop a heavy vehicle than a light vehicle, particularly when you're driving on a highway. You know, you've got to be have a good lookout. Okay, so that's Wright and Lodge, sort of similar to Knightley and Johns in that the result is similar. The court found there was a Novus Actus Interveniens. The second possible cause was not reasonably foreseeable. In Wright and Lodge, it was not reasonably foreseeable that the lorry driver would be so negligent in his driving. Okay, all right. Okay, so that's Knightley and Johns and Wright and Lodge. I'd say Knightley and Johns is your must-know case on Novus Actus Interveniens. It was not reasonably foreseeable that the police would act in without complying with their own standing orders. They made a series of mistakes which was not reasonably foreseeable. Okay, series of acts of ineptitude by the police was not reasonably foreseeable. Okay, now a little bit more on Novus Actus Interveniens. We've already covered that. And what we're covering now, everybody, is more should know than must know, but let's go through it. Exceptionally, some negligent acts, for example, medical treatment, may be considered foreseeable and not break the chain. This depends, okay. It's a Hong Kong case, but it's pretty rare, okay. In cases of negligence, as a Novus Actus Interveniens can usually sue the negligent intervener, so the plaintiff can succeed. Again, it depends on the facts, okay? And as long as you know the test, was the second cause reasonably foreseeable? Extending this to other acts, criminal acts generally do break the chain of causation because criminal acts normally are not foreseeable. There's a case, an English case called Lambda and Camden. And I've got a separate one on this. Again, should know, not must know. It's an interesting one, though. The defendant was a local government, negligently caused flooding and damage to the plaintiff's house, so that obviously satisfied the but-for test. The plaintiff then relocated because his house was not livable, and then criminals moved in and caused further damage. So was there a Novus Actus Interveniens? And the court found that the incursion of squatters was in fact unlikely, therefore not reasonably foreseeable. And so there was no Novus Actus Interveniens in the Lamb case. So the local government remained liable. Okay. And then in other situations, talking about criminal acts, for the defendant to be liable for another's criminal act must be very likely to happen. And it was not very likely to happen in the Lamb case. Okay. But there are other situations, the facts can change, where a criminal act is the very thing the defendant is under duty to prevent, so that could be liable. Okay, so don't worry about those cases, they're just particular illustrations on whether or not there is a Novus Actus Interveniens. So let's have a quick review of Novus Actus Interveniens. Remember, it's a question of reasonable foreseeability if there's more than one possible cause of the damage to the plaintiff. Okay? And so the court will look to see whether the second event was reasonably foreseeable. If it is reasonably foreseeable, the first cause remains the effective cause. But if the second event was not reasonably foreseeable, as in Knightley and Johns, it was not reasonably foreseeable that the police would make so many errors, then that broke the chain of causation. So it does depend on the facts of each case. It is an open question, so you have to look at it on a case-by-case basis. But I think Knightley and Johns is a good one. Okay. So case law provides some guidance, but policy considerations are also at play here. Okay, in that the important function of tort law, remember, is compensation. So you've got to make sure that the plaintiff is able to sue somebody and get compensation. Okay. So you can't really come up with any general principle here except to ask that question, was the second cause reasonably foreseeable? If it wasn't, then it would break the chain of causation and become the effective cause. Okay, everybody, so that's causation, and I think that's probably a good time now to have our first break. So I'll have a 10-minute break. After the break, I want to carry on a little bit with causation, albeit in a situation which is more should know than must know, but there's some interesting cases dealing particularly with employees. So you may well find this relevant to your own situation. Okay, so the courts are very keen to protect the interests of employees. So we'll be looking at causation in the employer-employee relationship. But we won't do it now. We'll do it after the break. Okay, welcome back everybody. Hope you had a good break. I got my hot chocolate. Yes, the expensive one from Starbucks, but you know, it's good for this time of night. Okay, so what I'm going to do is, well, we'll do a quick review of causation again, and then we're going to have a look at some situations which are should know, not must know. You know what I mean by that, all right? And then we're going to look at remoteness of damage. Now, remoteness of damage comes from the fact that negligence is what? Negligence is where a duty of care is owed by the defendant to the plaintiff, and there's breach causing damage, which is not too remote. So I'm going to talk about remoteness of damage as well tonight. A fairly small topic, but we'll see how we go. Also, we may be able to have an introductory look at the defences to negligence. So this is why I was fiddling around with my PowerPoint. I thought I'll better load that up, have it there just in case. And remember, what we will be dealing with after we deal with causation and then remoteness of damage, we'll be looking at defences to negligence. By the way, don't forget who has the burden of proof. The plaintiff has the burden of proving all of the elements of negligence: duty, breach, causation, and damage. But the defendant has the burden of proving any defence that they may rely on. Okay, and as I've mentioned several times, the most important defence to negligence is contributory negligence. Why? Because it's a partial defence, which means what? The plaintiff will always get something. Okay, and the main function of tort law, everybody, is compensation. So don't forget that. So one of the principles, the must-know principles here, the main function of tort law is compensation. There are two other defences to negligence we will look at. They both got fancy Latin names, but they can be summarised by consent or voluntary, and the other one is illegality or ex turpi causa. Now, both of those later defences are total defences, which means what? It means that the plaintiff gets no damages at all. Now, obviously, the law doesn't like total defences because the main function of tort law is compensation. However, it is possible that the defendant can prove those total defences, in which case, bad luck, plaintiff, you will get nothing. Okay, but we will focus mainly on contributory negligence. And as I say, we may get onto defences tonight. We'll see how we go, but it will be in sort of an introductory fashion. So you can read ahead, and I mean, plenty of time to do that over Chinese New Year, isn't it? You know, well, come on. I can't really go out too much over Chinese New Year, can we, in these COVID-19 days? Anyway, up to you. So a review of causation. I thought I'd just throw this PowerPoint in at the beginning of this set of PowerPoints. Remember the three, I'd say two must-know cases. Barnett is the one on the but-for test. Remember the person who drank the tea laced with arsenic. He would have died anyway, so there's no causation in the Barnett case. The but-for test was not satisfied. Okay, so the plaintiff would have suffered the injury anyway, even if the defendant was in breach. And the defendant in Barnett was in breach because he didn't come up to the standard of a doctor in those circumstances. Okay, when there's an emergency, bad luck, you have to just drop everything and go for it. Okay, so, and then the second aspect of causation is if there's more than one possible cause, what is the effective cause? And so this is the Novus, Actus, Intervenians cases. Was the second cause reasonably foreseeable? If it was, then the first cause remains the effective cause. But if the second cause was not reasonably foreseeable, it breaks the chain of causation and the second cause becomes the effective cause. Okay, so, and the must-know case, I think, suggest everybody is Knightley and Johns, perhaps Wright and Lodge on sort of similar facts. Okay. All right, now what we're going to deal with is situations here involving employers and employees. Now, whenever there's a case that goes to court involving employer-employee, whose side do you think the courts tend to be on? employees, okay? I mean, the law's supposed to be unbiased, but there's always a tendency to protect employees, and you'll see that in these cases. And again, none of these cases, everybody, is must know, but they're interesting ones. So it's where you have multiple causes. And the first aspect of this is what we call increased material risk. And McGee and the National Coal Board is a good illustration of this. Sorry, I'm just checking my notes here. And I don't know why your course manual deals with this before those other cases. Anyway, so we're on page 60. And in McGee, the plaintiff was employed by the defendant to carry to empty pipe kiln. It's very dirty work in McGee, okay? And after work, the plaintiff would ride his motorcycle, no, it wasn't a motorcycle, his push bike, home without washing because the defendant failed to provide washing facilities. Well, you know, everybody's skin is so sensitive, is it? You wait till you get a bit older. I'm always putting cream on my poor old skin, you know. Put the aqueous cream and I put all sorts of ointments. I mean, my skin's terrible. Okay, maybe you should eat more. Anyway, I was a tennis coach before. Did you know that? So, you know, I was out in the sun for a long time and it shows. All right, okay. So, the plaintiff began to develop skin problems, was eventually diagnosed with dermatitis, so a disease of the skin. So the employee sued the employer for negligence. But at the trial, medical evidence could not conclusively prove that the plaintiff's dermatitis was caused by the defendant's failure to provide washing facilities. Okay, so there was no causation, at least in the lower courts in McGee. But the plaintiff appealed to the House of Lords, and the House of Lords took an attitude very much pro-employee. And they say, well, he may not be able to satisfy the but-for test. And remember, the burden of proof would be on the plaintiff to prove that there was causation. And in McGee, the employee was not able to satisfy the but-for test. But Lord Reed held such a case the court should take a broader view of causation, held that the plaintiff was entitled to succeed, quote, if he can show that fault of the defender causes or materially contributed to his injury. Causes or materially contributed. So this is the material contributions case. Now, what do you mean by material? Good question. It's sort of a fairly vague word as well. And so the ruling in McGee can be seen as an exception rather than a rule. It's where the courts say, well, we think there should be a remedy for the employee. He might not be able to prove or satisfy the but-for test technically, but, you know, it's a material contribution, so that's good enough. The employer is liable, therefore the employee was able to claim compensation. Okay, so so the plaintiff was able to prove that the defendant was negligent in neglecting to provide proper washing facilities, and of course that extended the period of exposure to the risk of infection. It materially contributed to the disease. Okay. Also, the courts look at these diseases as diseases which occur cumulatively over a long period of time. Okay, so it's important to note, though, that of the context here, employer-employee relationship. Similarly, in the Fairchild case, Fairchild on page 61, this involved not damage to the skin, it involved damage to the lungs in that the damage was caused by asbestos, exposure to asbestos dust. And asbestos was used as a common material in ceilings for a long period of time before medical science discovered, hang on, this can be very dangerous to the lungs because the asbestos dust is so fine that it can get into the lungs and over time can cause very serious illness. Okay, so this raises the issue again, hang on, how are you going to prove causation here? Because in it's possible that the plaintiff could have worked for more than one employer. So who are you going to prove which one is available? Okay, So medical evidence was shown here. The disease is called mesothelioma. Medical science always has these tough words. Was an indivisible disease triggered on a singular unidentifiable occasion. So which employer was the one in which the disease was triggered, so to speak? Well, nobody could really say that. So the House of Lords considered it would be fair, just and reasonable to create an exception to the general rule of causation in this particular context. It would be sufficient if the claimant, the employee, could show that the negligent exposure had materially increased the risk or materially contributed to the risk that the worker would develop the disease. Okay, so what happened is that the court found all of the employers liable. Okay, so there were, I think, 2 or 3, so that you divide up the damages amongst them. So there you are. So it's an exceptional test. It's where the employee has a disease which is a cumulative disease. It's very difficult to strictly satisfy the but-for test, but the courts are looking to provide compensation to the employees. Okay? All right, again, sound is a problem. Some of us are pending for your approval to go back to the class. Okay, now I've already let everybody in. Okay? Everybody is in. I've let you in. Okay? Looks like it. I don't know why that. I always have it. There's a general bar here. Allow everybody in, and I've allowed everybody in. Okay, so if you are trying to get in, sorry, but I understand everybody's in. Hello, yeah. The number of participants is up to what it was before. Okay, good. Well, thank you for letting me know. All right, so there you are. Hang on, these touch screens, they're interesting. A new one. All right, so that's the material contribution cases. Now we come to even more complicated ones. So everybody, this is getting a little bit complicated, but well, before we leave the increased material risk causation, I've given you this particular PowerPoint which summarizes pretty well what I've just said. Sorry, get my PowerPoints spread out here. I'm in this big lecture room. I've got 2 screens I'm working on. There are 2 further screens in the background and 2 screens behind me. Screens everywhere. Okay, and I haven't got enough room for my notes. All right. So what are the conditions for increased material risk causation, as in McGee and Fairchild? Obviously, the substance causing the disease is known. So in McGee, it was dermatitis, the dust. I think it was coal dust. And in Fairchild, it was asbestos. And then the defendant's activity, the breach, produces that substance. And there are multiple sources of the substance, and it's not scientifically possible to trace exactly what was the trigger point. And so which employer would be liable? In that case, the plaintiff can prove causation simply by proving that the breach materially increased the risk of damage to the plaintiff. Okay, and then the defendant will be liable for all the damage. And if there's more than one employer, they'll all be liable jointly and severally. Okay, but it does seem to be confined to the employer-employee relationship, and the courts generally take a very lenient attitude when employees are suing. The law wants to be seen to be protecting employees, particularly in Hong Kong. You'll notice with workers on construction sites in Hong Kong are treated very well by the law, and there's plenty of legal recourse for any worker injured, particularly on a construction site in Hong Kong. Because construction sites in Hong Kong are inherently dangerous, because often they're on very steep slopes. Also, the buildings that are being worked on are probably multi-story buildings. So if you fall off a multi-story building in Hong Kong, good luck. Whereas you fall out off another construction building in other countries may not be quite so bad. You know, Hong Kong has more multi-story buildings than any other place in the world. I saw that somewhere. I'm not sure whether it was on Facebook. Is that true? But Hong Kong certainly has a lot of high-rise buildings. Okay, so that's the increased material risk causation. Should know, not must know. Yeah, even more should know, perhaps even bordering on might like to know. What happens if you have multiple causes? And there are a couple of cases here. trying to find out where they are. I don't think they're in the course, but we'll go through these because the facts are sort of dramatic. Okay, successive independent causes, and the case to look at. There are two cases: Baker and Willoughby, and Jobling and associated dairies. I must amend that PowerPoint because the blue doesn't look very clear. Let's have a look at Baker and Willoughby. This is an interesting case. I've given you the facts, but again, might like to know just to illustrate that sometimes causation can be a bit tricky. Particularly when you have these multiple causes, successive independent causes. Okay, so it's not, somebody's injured and then something happens and then 3 or 4 years later something else happens. How does the court resolve these complications? So there you are, Baker and Willoughby. The plaintiff's left leg was injured by the defendant's negligent driving, causing continuing disability. So the plaintiff's got a bung left leg. Before trial, the plaintiff is a victim of a criminal attack where the leg is shot and amputated. So how on earth does the court resolve that situation? Is the defendant liable for the disability for the period following the shooting? And did the defendant's negligence cause a continuing leg disability given that there is no leg after the shooting? Well, the court has to decide that somehow. Okay. And then another case, Jobling. Plaintiff's back was injured due to the negligence of the employer, causing continued disability. And then 3 years later, but before trial, which is interesting because these personal injuries actions do take a long time to come to trial. Okay, I've represented clients in personal injury actions where the accident occurred 6 or 7 years ago, and then before you actually get to trial. I mean, most personal injury actions don't go to trial because they normally are settled. But in this particular case, 3 years later, but before trial, the plaintiff acquired a debilitating disease, total disability, and the disease was unrelated to the defendant's back injury. So how was the court going to resolve this? So the issue is the defendant liable for the disability to the back for the period following the onset of disease? Did the defendant's negligence cause the continuing back disability, given that the disease caused 100% disability? Okay, so the courts decide these cases. There are competing principles. They will look at the nature of the supervening event. Is it supervening event tortious? In other words, somebody's at fault, or non-tortious? And then a principle which we're going to look at in a moment, the defendant takes your victim as you find him. Okay, so this again fits in with the main function of tort law, which is compensation. So if let's say you injure somebody and they suffer very serious injury, where other people may not even be greatly affected by it, well, bad luck. You take your victim as you find him, because tort law, the main function is compensation. The courts try to put the plaintiff back in the position they were before the accident. Okay. They'll also look at this principle of trying to put the plaintiff back in the position they were before the accident. So the plaintiff is entitled to full and fair compensation, but no more. So it's not to punish the defendant, it's to compensate the plaintiff. Also, the court, when they are assessing quantum of damages, and of course, we don't need to get into that in our course, but obviously in practice, the amount of money you get when you take out a civil action is very important to your client. But when assessing the amount of the plaintiff's loss, the court will look at various ways of calculating how much damages the plaintiff should receive. And in the next set of PowerPoints on remoteness of damage, I'm going to give you some indications of how the court quantifies damages. Again, should know, but not must know. But of course, in a civil action, remember the two big issues: is the defendant liable, so liability, but the other big issue is quantum of damages. On our course, we focus mainly on liability. We don't focus too much on quantum of damages because, well, But in practice, of course, it's quite important. Remember, as I think I've said before, quite often in a civil action, the defendant will readily admit liability, but then fight tooth and nail about how much money you have to pay. Okay, so how does a court calculate the quantum of damages? Well, they're trying to sometimes, one of the heads of damage is looking at loss of income. So you're working in a job earning, I don't know, a certain amount of money per month, and you're injured, so you can't work for a certain period of time. How does the court calculate your loss? Well, you can calculate your loss of earnings, but and what happens if you are very seriously injured and you may not be able to work at all? How can the court calculate how much money you might have earned? So the court's trying to look into the future, obviously very difficult to do. And the court has to take into account, what might happen in the future. There may be mishaps or accidents, the so-called vicissitudes of life. Life has its ups and its downs, okay? All right. And then the compensation has to be compensation. You can't be overcompensating the plaintiff, and you also can't be undercompensating them. In Baker, the court was careful not to undercompensate the plaintiff. It was the opposite in Jobling. Okay, all right. Again, might like to know, not even should know. So obviously comparing Baker and Jobling, where Baker applies, you disregard the second event, that is the extent of the defendant's liability unaffected by the subsequent event, whereas in Jobling, you take the second event into account and determine the extent of the defendant's liability. It gets pretty complicated, and it's only might like to know. But also there are some contradictions in these principles. Could you argue that an unexpected criminal attack is not a vicissitude of life? Okay, you don't expect to be criminally attacked. Certainly not in Hong Kong. Hong Kong's a pretty safe place, you would think. A disease contracted a few days after trial is not relevant, but isn't that arbitrary? Okay. And when is an event a tort? Does the tort, non-tort distinction not give rise to the need for what we call a trial within a trial? Again, technical points might like to know. It just illustrates it can be very difficult in when it comes to calculating damages. How does the court come to a figure which fits in with the main function of tort law, which is compensation, and particularly when you've got these multiple causes. Okay. So let's leave causation now, and I want to get on to an aspect of causation. In fact, it is covered in your course manual on page 63 very briefly. There should be a subheading in your course manual dealing with remoteness of damage. For some reason it's there. It's actually under the heading causation in law. I don't know why this should have been under the heading remoteness of damage. Again, should know, not must know, but it is important in practice. And there is one must know aspect of remoteness of damage we're going to look at in a moment. It also fits in with the main function of tort law being compensation. And that is the so-called thin skull rule. We're going to look at the thin skull rule in a moment. Okay, so what is remoteness of damage? Well, it's trying to place limits on the defendant's liability for the damage that has been caused. So again, we're in this area of quantifying damages, and this is not an easy area. The courts spend a lot of time on assessment of damages, and in particular, what types of damage can the plaintiff claim. Now, the leading case on this is a case called Wagon Mound on page 63. And in Wagon Mound, number one, there was negligence of the defendant, and a large quantity of oil flowed out into Sydney Harbour. The plaintiff in this case was the owner of the wharf, so he took advice as to whether it was safe to carry out welding operations when the oil was in the water. The advice was it was extremely unlikely that the oil would catch fire. However, they failed to take into account that there could have been some sort of rubbish in the water, which was flammable, and the welding operations of the plaintiff did ignite the oil because there was this extra, I don't know, timber filings or something, and the fire did extensive damage to the plaintiff's wharf. So was this damage too remote? The trial judge found the defendant did not know and could not reasonably be expected to have known that the oil was capable of being set on fire on the water. So it was too remote. And I've got an old case there called the Polymers Rule, which seemed to say the law used to be that you were only liable for damage which was directly related to the activity, but now the courts look on reasonable foreseeability of the kind of damage, and then that will be what the defendant will be liable for. So what must be reasonably foreseeable when it comes to the remoteness of damage issue? Well, it's the kind of damage suffered, not its extent. And the leading case on this is Hughes and the Lord Advocate, again on page 63. The defendant was a post office. The employees of the post office opened a manhole intending to repair the telephone system underground. Well, Hong Kong's pretty good at keeping all these facilities underground, so that's good. So this is what happened here. And so they were underground repairing the telephone system. They went on a tea break, of course, like we even go on our tea break, leaving the manhole open with only paraffin lamps placed next to the manhole and the weather tent to warn passers-by. Lo and behold, along comes an 8-year-old boy, climbed into the manhole, and there was a chain reaction. He knocked over the paraffin lamp into the hole. Violent explosion occurred as a result, knocked the plaintiff back into the manhole where he was severely burned. So, obviously, personal injury, sues in negligence. At trial, the judge rejected the plaintiff's claim on the grounds that the explosion was not reasonably foreseeable. But the House of Lords disagreed. They said, as long as the type of damage is reasonably foreseeable, then the plaintiff can claim. Okay? So it's sufficient if the accident is of a type which should have been foreseeable by a reasonably careful person. Okay? But again, it raises questions again of quantification. How do you categorize damages? How do you, what are the different types? How specific or general should you be? What about the different types of personal injury? So should know, not must know. Okay. I've given these other cases again, everybody, which are more should know than must know. None of these cases in your course manual, but some of them are interesting. Jolly and Sutton, it was a boat which had been abandoned, and of course children involved. They tried to jack up the boat. Kids do these sorts of things, and it collapsed on them. And the court said that you've got to expect children to get up to these sorts of things, and the ingenuity of children should not be underestimated. And the type of damage was reasonably foreseeable. Okay. Bradford contrasts Tremaine, dealing with rat's bite. The fact that if you're bitten by a rat, reasonably foreseeable, you might catch some sort of disease. But a disease caused from rat's urine sounds awful. But it's not reasonably foreseeable. I mean, that's just. And then back wall engineering, chemical exploding on contact with water, reasonably foreseeable. Okay. So fine, should know, not must know those cases. What you must know, though, is the thin skull rule. Okay. Remember the main function of tort law? Compensation. So this is the thin skull rule. And the general principle is, on the screen, you take your victim as you find it. And the leading case on this has a name which is a bit gory, so Smith and Leech brain. And Smith and Leech brain is on page 67. Where's it gone? Yeah, Smith and Leech brain on page 69 of the course manual. So let's have a look at the facts of Smith and Leech brain. An employee received a burn on his lip. when he was splashed with molten metal. Ouch. I mean, lips are very thin, skin's very thin. So the injury was a result of negligence by the defendant employer. Okay. However, the employee contracted cancer from the burn and thereafter died. I mean, you don't expect people to die from a burnt lip, but this is what happened. So was the employer liable? It was found that the employee had a pre-malignant condition from the time when he worked at a gasworks company, and the burn exacerbated the condition. And the defendant was held liable for the death. You take your victim as you find him. The fact that most people with that sort of burnt lip, wouldn't have died is irrelevant. This person did die. You take your victim as you find him. The main function of tort law is compensation. Okay? Which sort of reminds me, when I was driving my car, I used to always say, if you're driving a car and you're going to hit a car, you should have hit my old car, which wasn't worth very much. Don't hit a Rolls Royce, because if you hit a Rolls Royce, then the amount of money to repair a Rolls Royce would be a lot more than to repair my car, for example. Or if you're going to be in a traffic accident, make sure it's with a car that's old and not brand new, because if you're liable, you have to take your victim as you find him. You will have to pay that high level of damages. That's the main function of tort law, and this is the thin skull rule. So if you're going to hit anybody on the head, make sure they got a thick skull, like me maybe. Okay, so Smith and Leech brain, everybody, is a must-know case. It does come up in exam questions. Usually in part A of the exam, just say, explain what is meant by the thin skull rule. Well, not difficult when you know that the main function of tort law is compensation, and you take your victim as you find him. So if the victim suffers, very serious damage as a result of your negligence, well, you've got to compensate him, try to put him back in the position he was before the accident. Okay? So Smith and Leech brain, very important case. One of the academic issues that comes up here, can you reconcile this thin skull rule with the remoteness of damage principle? Remember, remoteness of damage, the defendant's only liable for the types of damage which are reasonably foreseeable. The court said that is not in conflict with the thin skull rule. Okay, so that's an important point to make. All right. And that's the last point on the screen at the moment. It survives the wagon mound reasonably foreseeable remoteness test. So the courts have definitely said this principle that you take your victim as you find him still survives. The thin skull rule survives. Okay, and more recent case of Simmons and British Steel, the plaintiff warned his employer that his working conditions were dangerous. The employer failed to take remedial action. The plaintiff was then injured in a fall while working, and during his hospitalization, the plaintiff became overwhelmed with anger towards his employer. I told you so, and you didn't take any action. Oh my goodness. So, and of course, he suffered a psychiatric injury as a result of this, including depression. And in the plaintiff's action for compensation, the defendant accepted liability for the plaintiff's physical injury, but denied liability for the mental illness or psychiatric injury. But the House of Lords said, no. House of Lords, sorry, the thin skull rule applies. You take your victim as you find him. And so in Simmons, the court allowed the plaintiff to claim damages for not only his physical injury, but also for his psychiatric injury. Okay? So there you are. The duty of care which the defendants owed, it should be owed, not just wed, owed to the victim, to the plaintiff, extended to the psychiatric symptoms as well as the physical consequences. The defendants must take their victim as they find him, so the aggravation of the psoriasis and the anger which led to his depression can both be assumed to fall within the scope of their liability, so long as there was a causal connection between these symptoms and the accident. So again, you notice it's an employer-employee relationship. And remember, in these situations, the courts are very much on the side of employees, and you take your victim as you find him. The main function of tort law is compensation. Also, employers should take out insurance to cover these situations. Okay, so there you are. Smith and Leech Brain. I think Simmons is also a good case to cite. Smith and Leech Brain's a little bit old now, 1962. Simmons is a House of Lords decision, much more recently. So I think Simmons would be a must-know case as well on the thin skull rule. Not difficult. So if you get it in the exam, probably part A of the exam, just explain what is meant by the thin skull rule. Well, there you are. You take your victim as you find him. And the main function of tort law is compensation. You could very quickly cite the facts of Simmons, in that the employee suffered not only personal injury, physical injury, but also psychiatric injury. And the court said that the employer was liable for both types of injury. But also Smith and Leech Brain, they are, and next time you burn your lip, okay, well, I hope you don't die, certainly. But, I mean, most people are not likely to die, but in Smith and Leech Brain, the plaintiff did die, and the court said, you take your victim as you find him. So there you are. If you're going to hit somebody who's really strong so he doesn't suffer any injury. If you're going to hit any object, make sure it's a very old object, not a very brand new object like a new car, because otherwise you will have to pay extra amount of money. Okay. All right, so that's the thin skull rule. Also, with regard to policy issues here, and these deal with the so-called the thin skull rule and policy issues, mentions a case back on page 67, Pygmy and Pointers. The plaintiff's husband sustained severe head injuries as a result of the negligence of the defendant. He became so depressed that he subsequently committed suicide. A little bit like Simmons. It was held that the chain of causation was not broken by the suicide and the defendants remained liable. So here, that was a causation issue. It was reasonably foreseeable that somebody who suffers head injuries might commit suicide. So in this situation, the courts really don't think it's an issue of causation. They think it's more an issue of contributory negligence. So in Pygmy and Pointers, the court held that was no Novus Actus Intervenians. Suicide was reasonably foreseeable and the type of damage was reasonably foreseeable. I've got another case there called Mayer and McCramer. Again, should know, not must know case. Pygmies and Pointers is the easy case, and it's on page 67. In Mayer and McCramer, the plaintiff's injuries caused criminal acts causing injury to others. So that's just a case that goes the other way. In the Mayer case, the court found that the damage was too remote because you don't expect somebody who suffers physical injuries to go then start committing criminal acts. Okay. Well, that's a decision that goes the other way. Again, it just illustrates where the fact that the policy issues here, the courts are very much more lenient now in where the victim commits suicide, because the courts 100 years ago, medical science 100 years ago was not very well developed when it comes to psychiatric illness or mental illness. And so the courts are very much aware that suicide is in the area of mental illness. And so they're much more sympathetic now because of the advances in medical science, which recognize mental illness as being just as serious as physical injury. Okay, now just to finish off this area of remoteness of damage, I thought I'd throw in a couple of PowerPoints dealing with quantum of damage and damages for personal injury or death. So this is all should know, not must know. This is not in your course manual. But when you sue in an action, a personal injury action, what type of damages can you get? Okay, and obviously this is very important in practice because we're all interested in money and lots of money perhaps. Now, there are different what we call heads of damage. And when you go, when you're in a civil action suing for negligence, for personal injury or death, there are damages which are called special damages and other damages called general damages. Special damages are these pre-trial financial losses such as medical expenses, lost income because you can't work. So you can claim special damages. Special damages can be calculated pretty accurately. Okay, medical expenses, just produce the receipts and you'll get your money. Lost income, produce your employment contract. You're earning a certain amount of money per month. How long are you off work before trial? Well, the court can calculate that pretty accurately. So they are called special damages, in which, if you like, easily calculable. But then there are other damages you can claim, and these are called general damages. And these are after trial, post-trial financial losses, notably future lost earnings. And this is where the court has to try and look into the future, try to figure out how much money you would have earned if you weren't permanently injured. And then, of course, there is some sort of discounting going on here, a multiplier, etc. So you can claim post-trial financial losses, future lost earnings. You can also get non-financial losses. You can get damages for what we call pain, suffering, and loss of amenities. Pain, suffering, and loss of amenities, PSLA. Also, it's interesting, literally, to note that interest is payable on these damages under the High Court Ordinance and District Court Ordinance. And the interest payable is not what you find on your savings accounts. It's it's the judicial rate. I'm not sure what it is at the moment, 3 or 4%. It's definitely not what you get on your savings account at the moment. We live in extraordinary times, don't we? Interest rates are at an historic low. I guess they will rise after some time, eventually will arise. Okay, so you can claim damages for pain, suffering, and loss of amenities. Well, how much do you get? Well, there you are. For pain, suffering, and loss of amenities, if the injury is serious, and what do you mean by serious? Well, it's pretty serious. You lose a leg or something. Reasonable mobility is lost. 80,000 Hong Kong dollars. I'm not sure whether these figures are up to date, but gives you some feel of how much money you might get. Substantial injury, which requires hospital treatment for long periods, 80 to 100,000 Hong Kong dollars. Gross disability, where you lose all 4 limbs, 100 to 150,000 Hong Kong dollars. Disaster, requiring constant care and attention, $150,000 plus. Actually, it's not that much when you think about it, but you do get something for pain, suffering, and loss of amenity, apart from loss of future earnings. Loss of future earnings would probably be your biggest part of your damages claim, but you can claim these other ones. Okay, would you tell me whether students have an extra face-to-face tutorial class or tort law, contract law assignment in the Hong Kong State Court? Oh, question from Cheng Hong Kong, whether students have an extra face-to-face. I don't know the answer to that. I hope we can get back to face-to-face teaching in March, and certainly for the revision sessions. Before that, I don't know. Certainly the classes scheduled for February will all be online. After that, I hope we get face-to-face, okay? And of course, better ask the government. I can't understand why you can't be here, everybody. Social distancing and all that. I'm in this lovely classroom with these very comfortable seats, which you probably go to sleep in. I mean, there seems to be plenty of space. I don't know. Okay, so there you are. Good question. I mean, everybody agrees face-to-face teaching is better, but I mean, we've got to be grateful we have any teaching at all. We're online. The advantage of being online is that these lessons have been recorded, so you can play them back again. So that's one advantage. Okay, but of course, usually face-to-face is much better. All right. Okay. So that brings us up to our next break, and then after the break, I want to have an introductory look at defences, which we will finish off next time we meet, which I think is the, well, after Chinese New Year. Okay, so we'll have our second break. After the break, we're going to look at defences. into the final stretch. So sort of an introductory, perhaps slightly more than introductory look at defences to negligence. I've also got occupiers liability. I'll be mentioning occupiers liability. Occupiers liabilities should know, not must know, but it's similar to negligence in that occupiers liability applies where you have an occupier, somebody who's control of premises, and he owes a special duty very similar to a negligence duty to visitors on the premises. Okay, so there is actually legislation in Hong Kong called the Occupiers Liability Ordinance. And so the defences we're going to talk about here are defences not only to negligence but also occupiers liability. Okay, quick word on the chat box from Cheng Hon Man. With regard to email, I normally don't give out my email as a matter of policy because I like all students to be treated equally. But if you have a question, by all means, let me know and I will answer it for you. If you really must contact me, you can always contact me through Space. But with regard to the assignment, again, I want to treat everybody equally. So any comments I make about the assignment will be to everybody at the same time. I've already mentioned some points about the assignment. Remember, I think question 1 is dealing with formation of a contract. Remember, how do you start off your answer there? A, or whoever it is, would like to know if there's a contract between him and the other person, full stop. Then the court will look for essential elements in the formation of a contract, agreement, consideration, etc., full stop. And then the only element and issue in your assignment question 1 will be the element of agreement, full stop. Then you cite the Gibson principle, and then you say that there are no exceptional circumstances. And so for answering question 1 in the assignment, you follow my guideline. Is there an offer? Has it been communicated? Is there acceptance? Has it been communicated? Or has the offer been withdrawn before acceptance? Okay. With regard to question 2, that's on private nuisance. We haven't covered private nuisance. We'll be covering that after we deal with defences. Okay. So that's your assignment. Also, I'll make some general comments about the assignment. Again, I'm not sure whether I flashed up a PowerPoint on what to look out for in the assignment, and also it touches a little bit on examination technique. I'll do so next time we meet. I'll talk about the assignment in general terms next time. But if I make any comment about the assignment, to be fair to everybody, it should be to everybody. Okay, so that's it. All right, so talking about defences now. And a reminder, first of all, of course, the elements of negligence. Remember, a duty of care, and this time I've got them in sort of the A, B, C, D order. There must be a duty of care owed by the defendant to the plaintiff. There must be breach of the duty, depending on the standard of care, and then causing damage which is not too remote. And then, of course, that's not the end of it. Remember, we have an adversarial system, plaintiff v. defendant. V stands for versus. So it's somebody against somebody else, and the defendant can raise defenses. So who has the burden of proof? Well, the plaintiff has the burden of proving all of the elements of negligence. The defendant has the burden of proving any defense. Okay? So burden of proof is important. Having borne that in mind, though, remember what we covered earlier tonight with regard to breach of the duty of care, with regard to Section 62 of the Evidence Ordinance. Remember, the relevant criminal convictions can be admitted as evidence in the civil action. The burden of proof is reversed under Section 62. So that's an important exception to the fact that the burden of proof is on the plaintiff to prove all the elements of negligence, but when it comes to proving breach, if Section 62 applies, the burden is reversed and put on the defendant. But generally, the plaintiff has to prove all the elements of negligence, and the defendant has to prove all the elements of a defense that he raises. The general principle is, everybody, he who asserts must prove. Okay? So if you are asserting that there is a defense, you've got to prove it. So what are the defenses to negligence? Well, there are 3. The first one has a Latin expression, volenti non fit injuria, which means what? Volenti means consent, okay? And it is a total defense. Total defense, which means what? Plaintiff gets no damages. The second defense is another Latin expression, extirpe causa non oritur actio, shortened normally to simply extirpe causa or illegality. Again, that's a total defense. The plaintiff gets no damages. The third and most important defense is contributory negligence. And it's not a total defense, it's only a partial defense. It used to be a total defense under the common law, but legislation has been enacted which makes contributory negligence now a partial defense, which means what? The plaintiff will have his damages reduced, but will still get some compensation. So which one do you think the court favours? Well, no prizes for guessing contributory negligence, because the main function of tort law, everybody, is compensation. Okay, so most important defense will be contributory negligence. Okay, well, let's have a look at volenti first, because volenti has some interesting cases. What do you mean by volenti? It's also known as voluntary assumption of risk, okay? And it is a complete defense, a total defense, same thing. What must the defendant prove in order to succeed in a claim for volenti or consent? The defendant must prove that the plaintiff had knowledge of the risk, and as to the nature of the risk and the extent, had agreed to accept the risk, in other words, had waived his rights, and had acted voluntarily. And all of these are measured subjectively. Okay, so on page 125, some cases there. We'll look at some the must-know cases in a moment, but rescuers, I talked about rescuers here. Do you consent to the risk if you're a rescuer? Well, normally not, okay. Where the plaintiff acts to save another from injury is not deemed to assume the risk of the consequences, even if he acts voluntarily with full knowledge of the danger. That's sort of common sense is the way. There's a case called Haynes and Harwood on page 125. Okay, so it's a question of fact again. Has the plaintiff assumed the risk? Okay, did he have knowledge of the risk, agreed to it, and acted voluntarily? Well, in that case, that will be a total defense. The must-know case, well, there are probably three must-know cases, I think, on volenti. The first one is ICI and Shatwell. And ICI and Shatwell's on page 121. It's an interesting one because it concerned two brothers who were employed by the defendant to work at the defendant's quarry. They were in the business of handling explosives, and they were instructed to carry out explosive work, but they were hungry. Oh my goodness. In order to save time, they did not follow the safety instructions given by the defendant to test the detonators under a proper shelter. They took a shortcut because they were hungry, wanted to get out and have lunch. Okay, so they did not follow the safety instructions to test the detonators under a proper shelter, but they did the testing in an open space. And the plaintiff was seriously injured in an explosive during the test. So the plaintiff sued his brother for negligence, which is an interesting one. I guess they were no longer friends, a bit like Alcott, remember? Alcott was a brother who suffered nervous shock, and he claimed a duty of care was owed to him, but the court said, well, was there sufficient proximity of relationship? Well, the brother in Alcott failed because he failed to show close ties of love and affection. Well, in the Shatwell case, there was certainly no love and affection suffered here, because He sued his brother for negligence and the defendant as employer based upon vicarious liability. You know what vicarious liability is, don't you? In the employer-employee relationship, the employer is liable for damage caused by the torts of his employee acting in the course of employment. So highlight vicarious liability by way of a reminder. You know what vicarious liability is. But the House of Lords refused to grant relief. Why? Because there was a total defence of consent. The plaintiff had known about the risk, the extent and nature of the risk, had voluntarily assumed the risk, full knowledge of the potential danger of not following the safety instructions. He nevertheless elected to go ahead with the test in an open space. Okay, so there you are. There was consent found in Shotwell. So if you're feeling hungry, be careful. Don't take a shortcut. Now, an interesting case which goes the other way is IP and Film Power. IP and Film Power is on page 123. And in IP and Film Power, it concerned a stuntman. Okay, well, Hong Kong, had a flourishing film industry. Was it Run Run Shaw? Was it the other one? Anyway, but I went out to their film studios in Clearwater Bay once. Anyway, so IP and Film Power, the plaintiff was a part-time stuntman engaged to perform a stunt for a film. So there you are. This is sort of interesting. He was supposed to drive a 16-seat minibus and force the minibus to drive into the sea as if he had lost control of it. Well, dangerous. Okay. After the minibus plunged to the bottom of the sea, the plaintiff was unable to swim to the surface as he's planned, nearly drowned, well, of course, because of insufficient safety precautions taken by the filmmaker. So was this voluntary? Was this consent? The court said no. Okay, the defendant said it was, but the court found, as a matter of fact, there was obvious pressure on the plaintiff to do this particular stunt, and there were insufficient safety precautions, so there was not proper consent. He did not have full knowledge of the risk. The risk was that the proper safety measures were not in place. Okay, so the plaintiff did not fully consent to the risk, and so the defence of Voluntary failed in IP and Film Power. So it's good to have two cases which with opposite conclusions. So in Shotwell, Voluntary succeeded, the plaintiff got no compensation. But in IP and Film Power, Voluntary did not succeed, and so the plaintiff did get compensation. And now an interesting case here, Morris and Murray. Morris and Murray on page 123, interesting one. Morris and Murray. Plaintiff boarded an aircraft, not a vehicle on the road. And this is an important point. Before the flight, the friend had consumed considerable amounts of alcohol. The weather was bad. All right, got the picture? Shortly after takeoff, the aircraft crashed, not surprisingly. The accident killed the pilot, seriously injured the plaintiff. So the Court of Appeal accepted under these circumstances the plaintiff had voluntarily assumed the risk and the defence of Voluntary was established. Morris and Murray. Now on the PowerPoint, I've got the plane was not a vehicle on the road. Why is that important? Well, the answer is because, and this is where your course manual falls down a little bit. There are statutory restrictions on Voluntary, and they're coming up in a PowerPoint soon. But in Hong Kong, if you're in a vehicle on the road, Voluntary will never succeed as a defence because there is legislation which says that passenger agreements shall be of no effect. So if you're in a vehicle on the road, let's say you're walking along the road and somebody offers to give you a lift and the driver says, I'll give you a lift to Checo or wherever, providing that you won't sue me if there's any accident. Well, if you agree, that passenger agreement will be of no effect because there's legislation in Hong Kong which says so. There's also legislation in England which says so as well. So if you're a passenger in a vehicle on the road, Voluntary will not work. So this is why in Morris and Murray, though, the defence of Voluntary did succeed because it was not a vehicle on the road, it was an aeroplane. Okay, so important point to note about Morris and Murray and aeroplane. So Morris and Murray, the passenger had voluntarily assumed the risk. He knew the pilot was drunk, he knew the weather was bad, but he hopped on. Okay, so Morris and Murray, the defence of Voluntary did succeed, yes. And then there are other cases which I haven't got on my, oh yes I have, Titchener and the British Railways Board on page 121. Titchener is an interesting one in which the defence did succeed. The plaintiff was trespassing on railway premises. After slipping through a fence, she went across the railway line, was injured by an oncoming train. House of Lords held that she clearly knew the risk of being hit by a train when crossing the line, yet she decided to take the risk. So even though the driver was negligent, the defence of consent or Voluntary did succeed, okay? And so there was a voluntary assumption of risk by the plaintiff, okay? So do you actually need an actual agreement? The answer is no. Okay, but the House of Lords found that the plaintiff voluntarily accepted the risk. So be careful. Don't go onto the MTR train lines at any time, or Kowloon Railway, or indeed out in Chun Mun, the light rail system. Okay, stay off the tracks because that could be voluntary assumption of risk. Okay. Also, Titchener, by the way, was actually an Occupiers Liability case because she'd actually gone onto premises controlled by the railway. All right, but there was Voluntary succeeded in Titchener. Okay, so far, if you like, it's 3-1. Shatwell, Voluntary succeeded. Morris and Murray succeeded. Titchener succeeded. Other cases, Gary is a more recent case, and this is an interesting one. What's today? Today's Tuesday. We're coming up to Chinese New Year. Are you going to celebrate at all? I don't know. Hope if anything's open. Court considered the extent to which an individual has responsibility towards her own safety entering and leaving certain premises. So the defendant, a Miss Weatherspoon, the Weatherspoon, sorry, is a well-known chain of public houses in the UK, concerned a public house converted by Weatherspoon from a large 19th century gentleman's club, whatever that was, in the centre of Newcastle. Newcastle's in the north of England, you know, run-down place. Anyway, the premises contained a large open staircase with banisters on each side. From time to time, customers had been tempted to slide down the banisters because we do these things, don't we, when we're celebrating. Some had injured themselves as a result. In this case, the claimant, Geary, visited the pub with some work colleagues. Okay, and you get a bit carried away, don't you, when you're in a group. And on leaving the pub, she attempted to slide down the banisters, fell backwards, landed on a marble floor, ouch, suffering a spinal fracture resulting in tetraplegia. In other words, both arms and legs were paralyzed. She admitted she had appreciated there was an obvious risk of falling attached to her actions, but argued that this was at best contributory negligence. So was this contributory negligence or was this Voluntary? The court found that it was indeed Voluntary, okay, because it was she went a bit overboard, okay. The claimant was the author of her own misfortune. As such, the defendant owed no duty to protect her from such an obvious and inherent risk. It's interesting, they should have had some sort of notice. You know, anybody who rides down the banister does so at their own risk. And when you invite a person into your house to use the staircase, you don't invite them to slide down the banister. Fair enough. So this is the result of the case in Geary. All right, so Voluntary did succeed in Geary. So now what, it's 4-1. Shatwell, Morris, Titchener, and Geary all succeeded in pleading Voluntary. Ip and Film Power, no Voluntary. Okay. Also other cases, which are not on the screen, Dan and Hamilton on page 122, a very drunk driver. Let's have a look at Dan and Hamilton on page 122. The defendant not only required to prove that the plaintiff consents to the risk, but also the plaintiff had full knowledge of the nature and extent of the risk involved. And in Dan and Hamilton, the plaintiff and her mother agreed to ride in a car driven by Hamilton to see the coronation decorations. Oh, isn't that lovely? When they got in the car, they realized that Hamilton had consumed alcohol. Well, what happens if you get into a car and you think the driver is drunk? Well, you should try and get out as soon as possible. Anyway, another passenger refused to ride in the car, warned the plaintiff of the possible danger of riding in a car driven by a drunken driver. Plaintiff responded, if anything's going to happen, it will happen. Oh, that's a bit cavalier. Continued to journey in the car. Due to the Hamilton's negligence, serious accident occurred in which Hamilton was killed and the plaintiff injured. Okay, so the question here, was this Voluntary? Court of Appeal said, given that when the plaintiff was warned about the danger, she responded, well, what will be sort of thing. Did the plaintiff voluntarily assume the risk of negligent driving? Asquith J held that the evidence did not support the plaintiff had accepted the risk of Hamilton driving negligently. Anyway, so interesting thing though, this is actually a vehicle on the road, and I'm not sure about in 1939 whether the legislation applied, but if that happened today, Voluntary would not succeed. And the reason's coming up, okay? Not yet. We'll deal with the next one. What about suicide? If you kill yourself, is that Voluntary? The answer is no. Voluntary is not applicable in suicide cases, even when the victim is of sound mind and knew what he was doing. The law used to be that there would be Voluntary if you knew what you were doing, but there would not be Voluntary if you did not know what you were doing because of some mental illness. In other words, you are of unsound mind. But that distinction has been abolished now, as evidenced by the Reeves case. And in the Reeves case, the victim did commit suicide. Reeves is on page 124. He committed suicide while in police custody. The police said, aha, Voluntary, he's killed himself. Right? He knew what was going on. And the court said, no, this was a case of contributory negligence in the Reeves case, and there was no Voluntary. And in Reeves, the court found that there was contributory negligence, quite a high percentage, 50%. Okay. Also, there's a case of Orange, and the Chief Constable of West Yorkshire, in that there was no Voluntary because the police did not know of any suicidal tendencies. So it does depend on the facts sometimes of each case. All right, now before we go tonight, I'm going to leave you with some legislation, which is not in your course manual, but I think should be. And is it this one? But I'm not going to worry about rescuers later. This one. Now, of course, none of you will be in a vehicle on the road going home tonight because you're already home, aren't you, Lucky? And I won't be in a vehicle on the road either. I'll be on the mass transit railway, aren't I, Lucky? But there are statutory restrictions on Voluntary. Some of this you already know, some you don't. The first bullet point, should know, and again, this is because mainly it's contract law. Exemption clauses in contracts, okay, cannot exempt liability for negligence causing death or personal injury. Remember from our work on exemption clauses in contract law, what is an exemption clause? It's a clause in a contract which excludes or restricts liability for either misrepresentation, breach of contract, or negligence. So here we are talking about negligence. And Section 7 sub 1 of the CECO says you cannot exempt liability for negligence causing death or personal injury. Full stop. So exemption clauses cannot be raised as a defence to a claim for negligence if the damage is death or personal injury. However, Section 7 sub 2, remember, does say you can exempt liability for negligence causing other damage, providing it is reasonable. So first bullet point, good revision. Remember, contract law. And remember, this is another example of overlap between contract law and tort law. Okay, so you know the definition of an exemption clause, don't you? You know where exemption clauses come in, don't you? They are raised as a defence to a claim for either negligence, misrepresentation, or breach of contract. Okay, but if you're trying to exclude liability for negligence causing death or personal injury, won't work, full stop. Okay, now the last bullet point, everybody, I will leave you with tonight, and I challenge you to go and look it up on your smartphone or computer somewhere. Section 12 of the Motor Vehicle Insurers Third-Party Risks Ordinance. Say again, Section 12 of the Motor Vehicle Insurers Third-Party Risks Ordinance. I don't know what cap number it is, but you can look it up alphabetically. Okay, says passenger agreements, if you're in a vehicle on the road, shall be of no effect. Shall be of no effect. And the case, English case on this is a case called Pitts and Hunt. Pitts and Hunt's an important case, and Pitts and Hunt is relevant to both Voluntary and also extirpi causa. Okay, but in Pitts and Hunt, on page 127, they had been drinking together before Pitts rode on the back of a motorbike. Well, motorbike's a vehicle on the road, being driven by Hunt. Pitts knew that Hunt was drunk. He did not possess a driving license, being under the legal age for driving, and that he was uninsured. But he still got on the bike. There was an accident, and he encouraged Hunt to drive recklessly, which was actually illegality. We'll cover that next time we meet. But let's talk about the Voluntary aspect of Pitts and Hunt. So Hunt was killed in an accident and Pitt was seriously injured. So Pitt's claim against Hunt's personal representative was rejected by the Court of Appeal. And the interesting thing here was that Voluntary did not apply in Pitts and Hunt, even though he sort of assumed the risk. He knew that the driver, the rider, was drunk and unlicensed, etc. But Voluntary did not succeed in Pitts and Hunt because of relevant legislation in England, very similar to Section 12 of the Motor Vehicles Insurers Third-Party Risk Ordinance. Okay, Pitts and Hunt, though, will do see the defence of extirpi causa did succeed in Pitts and Hunt, okay, but not Voluntary, because there are statutory restrictions on Voluntary, and the important one is Section 12, Motor Vehicles Insurers Third-Party Risks Ordinance. So look that up. I suggest Section 12 is must know, because I think you'll agree with me that's very important, isn't it? Because how often are we, in a vehicle on the road in Hong Kong? So even if you hop on into let's say a car, and the driver says, I'll give you a lift to somewhere, but on condition you agree not to sue me if there's any accident. Well, such an agreement shall be of no effect. Voluntary does not work if you're a passenger in a vehicle on the road. Remember Morris and Murray, the plane was not a vehicle on the road. Okay, Pitts and Hunt, it was a vehicle on the road, a motorbike. So in Pitts and Hunt, the defence of Voluntary did not succeed. What did succeed, and we'll look at this later, is the defence of illegality or extirpi causa. So there you are. That's pretty well it on Voluntary for tonight. But remember, Voluntary is a total defence. Courts don't like total defences. You know why, because the main function of tort law is compensation. So if Voluntary succeeds, it's a total defence. the plaintiff gets no damages. Okay, but so Voluntary will not work with the vehicle on the road. So I think you'll agree, quite important piece of legislation. It's a shame your course manual doesn't have it, and it does apply in Hong Kong. And I challenge you to go and look it up, okay, and read it. Okay, Cap 270, it sounds like that. Motor vehicles insurers, third-party risk order. Yeah, go and read it. I mean, you're law students, come on. I know legislation's boring, but what you read is what the law is, and the wording is quite clear. Such an agreement shall be of no effect. Can't be clearer than that, okay? So each time you're on a vehicle on the road in Hong Kong, say to the driver, if I sue you for negligence, you can't rely on Voluntary as a defence. Okay. All right, so Pitts and Hunt, good case on that. We'll revisit Pitts and Hunt next time because we will deal with the other defence, which is a total defence, illegality or extirpe causa. However, the most important defence to negligence, everybody, is, where is it? Contributory negligence. And contributory negligence, everybody, the main law on that is Section 21 of LACO. So everybody, just to sum up tonight, we've covered some must-know legislation tonight. Section 62, Evidence Ordinance, by way of revision. Section 12 of the MVI TPRO, and coming up next time, Section 21 of LACO. Now, Section 21 of LACO is set out pretty well in your course manual, so read it. And the law on contributory negligence now is largely in Section 21 of LACO. We'll also be looking at some must-know cases on contributory negligence as well. Okay, so a little bit of reading to do, and then we'll finish off defences next time we meet. And our next topic after that will be private nuisance. And private nuisance is the subject of question 2 in your assignment. So I will make some general comments about the assignment next time we meet. Okay, and also you'll find the question 2 in the assignment is not a difficult one once we've been through private nuisance. Okay, everybody, so that's it for tonight. It just leaves me to say, Kungi Fat Choi, everybody. Hope you have a good year of the ox. Hope it's much better than the previous year, because that's going to depend largely on the virus, for heaven's sake. All right, so thank you very much for your attention. And you've got some reading to do. Some interesting cases, I think, you find on tort law. That brings the subject alive for you, make it relevant to your own personal situation. Okay, so that's it for me. Thank you very much. I'll see you all. I think it's, when do we meet again? I think it's Thursday, isn't it? The 18th. I think it's Thursday, the 18th. Okay, thank you very much, and enjoy your break over the Chinese New Year. Stay safe.